Good morning, everyone. Welcome to today's hearing. I'm very pleased to say that with effect from today, we're able to welcome back a limited number of members of the public to observe the proceedings, which is a very welcome development. I hope that as time goes on, it won't be very long before we can welcome a larger number, but for the time being, we have to limit numbers until we see how matters develop with the pandemic. But it's a good development for us, and I hope for them to be able to come and see and hear what's going on. Today we're going to continue hearing evidence from Amanda Johnson, so I'd ask please for Mrs. Johnson to be brought in. Good morning, Mrs. Johnson.
Good morning.
Ready to carry on with the questioning?
Yes.
Good, thank you very much. Yes, Mr. Kinnear.
Thanks, sir. Good morning, Ms. Johnson. Last Thursday, we were discussing the various provisions in the MMA that dealt with the management of projects, and I took you to an email chain between you, Celia Chaliscan and Jane Trethui from the 17th of July 2012. And in that correspondence, you raised a concern about whether the MMA covered such projects as Grenfell and was its sufficiency for those purposes. Now, I asked you a question as to why you had those concerns, and you replied in this way, and it can be found at day 130, page 164, lines 12 to 23. It might not have been the MMA in retrospect. It might have been the schedules which set out the operational procedures. So we didn't have one around resident engagement side in terms of comms on major works. And also we didn't have, whilst we delegated all the capital programme management to the TMO, we didn't have a specific reporting mechanism in the schedules. So I think it was a mixture of the schedules needed to be updated as well as looking at the MMA itself. Now, could we go back to look at the 2006 MMA, which can be found at RBK 000-19006/163. Now, as you can see, this is in Volume 2, Chapter 2, and is Schedule 3 of the MMA and is entitled Principles for Management of Major Works Schemes. First of all, are you familiar with that schedule?
Yes.
Now, if we can go to paragraph 2.1, which can be found at page 165, which is internal page 34, we can see there that it provides for the setting up of a client review group, and its role is defined some 6 lines down in the sentence that starts the role of this group. And it says this, and I quote, "The role of this group will be to act as client for the project, review progress in implementing the scheme, and focus on those issues which directly concern residents. Where it is decided not to establish a client review group, the Residents' Association will be asked to nominate a representative to join the project team." Were you aware of that provision at the time?
I cannot recall that.
Can we now turn to page 167 and paragraph 5.2? Now, that provides that the Residents' Association will be involved in the selection of consultants, including architects. Were you aware of that provision?
Yes.
And what steps did you take to ensure that the requirements of that provision were satisfied?
I believe that there was a resident involved in the initial procurement. I believe that did happen.
Did you check to see whether there had been resident engagement and involvement in the selection of all the consultants and specialists involved in the project?
At that time, I wasn't responsible for that part of the work. That was dealt with by the regeneration team. So I wasn't actively involved in those kind of pre-site work arrangements.
Now, if we can go to paragraph 15.3, which is, I think, at page 175. We see it's very top of the page. Now, that provides for Resident Association representatives to attend site meetings. Were you aware of that provision as well?
Yes. Yes.
And what did you do to ensure that that requirement was satisfied?
We did a protocol around resident engagement with the TMO at the pre-works phase. We had regular meetings with the TMO. We agreed that they would lead on the consultation with residents. There was an established residents association there. They took a number of steps to consult with residents, and they consulted with residents about how residents wanted to be involved.
And you essentially left it to them to make the necessary arrangements with
It was agreed with the TMO that they would lead on resident consultation, yes.
Now, could I now ask you to turn to page 177 and paragraph 22.1, which says that all schemes will be subject to a post-project review. After completion of the project or on sectional completion, residents will be asked for their view on the way the work was carried out and what they like or dislike about improvements to their homes. The survey will also seek to collect BME data. Were you aware of that provision?
Yes.
And what steps did you take to ensure those requirements were satisfied?
I think things got overtaken because not long after the works were finished, we got the petition from residents. So the scrutiny committee initiated that the TMO board should review the outcome of the project. We also did do a survey of residents about how they'd experienced the works and what the impact was for them, but we got a very low response rate on that.
Now, do you agree that at least the 2006 MMA did contain provisions dealing with resident engagement on projects such as Grenfell?
Yes.
And this version of the MMA would, I think, have been enforced throughout a significant proportion of the Grenfell project. Would you accept that?
Yes.
Did you have any formal arrangements for monitoring the TMO's compliance with the sections that I've taken you through?
That would have been on the main highlight report. There was a section on communication with residents, and at the asset management meetings we would go through the highlight report and talk about resident involvement. There were quite a few issues with resident involvement towards the latter stage of the project because of residents concerned around the location of the boilers. So we were very aware about the steps that the TMO were taking to talk to residents.
Now, can we turn to the project's protocol, which was embedded in Schedule 9 of the 2015 MMA, and that can be found at RBK /2368/14. There we go. And if we can go to Schedule 3, which can be found in the same document but at page 6. Now, it said that schedule was, quotes, to be reviewed, close quotes. Can you help us? What was the status of Schedule 3 after the MMA was signed on the 26th of November 2015?
I cannot recall that.
Do you know anyone who would be able to assist us with the answer to that question?
Celia Chalice-Khan.
Thank you. Now, in relation to the phrase "to be reviewed," was there an intention that the Asset Management Projects Protocol would replace Schedule 3?
I suspect so.
What's the basis of your suspicion in that respect?
Just that we needed to, there wasn't sufficient documentation in the schedules around the management and major works, particularly in terms of resident engagement. So I suspect that that's what that was.
Can you remember now who may have been responsible for deciding that the Asset Management Projects Protocol would replace Schedule 3?
That would be between me and Celia, liaising with the TMO Company Secretary.
Can you now remember whether a formal decision was made in that regard?
I cannot recall, sorry.
Now, could we look at the Asset Management Projects process itself, and in particular Section 4, and if we go to RBK 00050-409/2, and if we go to the heading Resident Consultation at the bottom of the page, I'll just let you refresh your memory of that.
Mm-hmm.
Do you agree that there's no reference there to a client review group?
No, there isn't.
Would you agree that there's no reference either to residents being involved in the selection of consultants?
Not in sufficient detail, no.
Was there an intention, therefore, in 2015 to alter and minimise the degree of resident consultation required under the MMA?
Absolutely not.
Given there had been a removal of the client review group, and given there was insufficient detail regarding the selection of consultants, how can you deny so adamantly that there was an intention to minimise the degree of resident involvement?
I just think that when we drafted this, we did not align it with the other documentation appropriately. There was no direct omission.
Can I now turn to a diary entry in one of Laura Johnson's day books? It's dated the 23rd of July 2014. And if I could ask you to go to RBK 000 59574 /125. And if we can see in the top left-hand corner 1.1 AJ, and then underneath the date 23rd of July 2014. Now, to the extent you can answer this question, would that have been a note from a one-to-one meeting you had with Laura Johnson?
Yes.
Now, you'll see the second arrow down is next to the words underlined Grenfell Tower. And it seems to say, Grenfell Tower met with team at TMO to discuss, managing Eddie Defan and resident liaison, major capitals project look at MMA for level of monitoring required, Roger and Amanda meeting Vernon, going for a site visit. Do you remember that meeting?
I don't recall that specific meeting, no.
Do you recall being asked by Laura Johnson to review the provisions of the MMA in relation to monitoring required on such projects?
I don't think Laura specifically asked me to review the MMA. That was something that myself and Celia had already embarked on.
For the purposes of complying with Laura Johnson's direction, did you review Schedule 3 of the MMA?
I cannot recall doing that. I think we did an additional documentation to fill in the gaps in the MMA.
Now, in relation to Grenfell, did you ever raise with the TMO that, first of all, there was no client review group?
No, I didn't. I felt that they were on top of the consultation with residents.
And in that regard, did you ask the TMO why there had been no residents' associations involved in the selection of contractors?
No, I didn't.
Did you ask the TMO why there had been no resident association present at site meetings?
My understanding is that the TMO started with open meetings which were open to all residents, including the Residents' Association. They then subsequently consulted with the residents, and my understanding is the preference was for one-to-one drop-ins and one-to-one consultation. So I understood that that was residents' preference.
Now can we move on to a separate topic, which is the oversight of fire risk assessments. Mm-hmm. And if I could ask you to go to your first witness statement, which is at RBK 000 33719 /8, and paragraph 45, where you say this, and I quote, "The TMO then began commissioning fire risk assessments of all properties. A large tranche of these assessments had to be done for the first time, as the new regime, the Regulatory Reform Fire Safety Order, was implemented for the first time. Thereafter, fire risk assessments became planned as part of a rolling programme of updates. This would have entailed significant spend and had to be planned as part of the budget." What control did RBKC exercise over the budget for fire risk assessments?
We would meet on a regular basis with the TMO to look at the HRA business plan. I would work on that with Steve Meller, who was our finance lead. We would ask the TMO to put forward their priorities for spend in terms of the capital programme, and then we would build that into the business plan.
And what oversight would you or your department exercise over the expenditure of that budget, FRAs?
We wouldn't necessarily get into the specific detail about the individual budget. That would be something that finance colleagues would pick up with their counterparts in the TMO.
Did the TMO ever ask for further resources in order to enable them to carry out and complete the rolling programme of FRAs?
Initially, when the reform order came in, we did agree additional resources. We also agreed additional resources for the door closers after the Adair fire.
Dealing with FRAs after 2005 order came in, after that initial increase in resource, were any further requests made for additional resources for FRAs?
Not to the best of my recollection.
And was it as a response of a TMO request that additional funds were given in respect of door closers?
Yes, yes.
Were you aware of the process the TMO undertook to procure fire risk assessments?
They followed the procurement regulations. One of my staff, and much more, was involved in that in 2010. I think that procurement started just before I took responsibility for the client side. So one of my staff was actually involved in the procurement of the fire risk assessor.
To what extent did the housing commissioning team have any oversight function in relation to the substance of the FRAs?
That was all delegated to the TMO. They carried out operational responsibility for completing the FRAs.
Could I ask you to turn to Janice Ray's first witness statement, which can be found at TMO @000 0890/35. And if I could ask you to turn to paragraph 157 at the bottom of the page, where she said this, and I quote, "The FRAs themselves were shared as required within the organisation. RBKC did not receive copies as routine, although the minutes of the Health and Safety Committee meetings were copied to the Corporate Health and Safety Manager. Furthermore, progress in relation to the outstanding FRAs and FRA actions was included in the mid-year and year-end reports on the TMO's performance, which were presented to the RBKC Scrutiny Committee and in the annual TMO Health and Safety Report, which was shared with the Corporate Health and Safety Manager. Extracts were also included in his annual report, which was sent to RBKC's Health and Safety Committee." Did you see the reports from the TMO's Health and Safety Committee?
No, not routinely, no.
Is it right that you wouldn't receive the individual FRAs in relation to the TMO housing stock?
Yes.
Did you ever ask to see any FRAs, for example, after the Adair Tower fire or after service of any enforcement notices by the LFEPA?
No.
Can we look at paragraph 3.6 of the 2015-16 TMO Performance Agreement? And that can be found at RBK *000 0589/29. That refers there to programme of FRAs and reviews to continue and more work to ensure actions and recommendations from these are consistently completed in a timely manner. Who would have drafted, and it's the third bullet point, who would have drafted that section of the review?
Janice Ray.
Were you provided with any other information about what was being done about actions to close out FRA actions?
No.
What information over and above the statement here were you provided with when reviewing this review document?
The main oversight would be through meetings that we had with the TMO, the KPIs, which did not include fire risk assessments, through regular liaison with Janice. That would be how we would know.
And we did deal with this in some detail on Thursday, but looking at this particular review document, which was from 2005-16, what was the extent of your awareness that actions and recommendations arising from FRAs had not been closed out as timeously as they should have been?
I didn't know that.
Now, can we turn to the enforcement notices that served in relation to Adair Tower? Mm-hmm. Now, we know there was a fire at Adair Tower on the 31st of October 2015, and on the 23rd of December 2015, the LFB issued an enforcement notice addressed both to the Council and the TMO following that fire. Now, if we could turn to that notice, which is at RBK 000 29298. Now, do you remember whether you saw that enforcement notice after it was issued?
Yes, I did see it.
Who gave it to you?
It probably would have gone to Laura, who would have copied me into it.
Given that you had been told there was a rolling programme of FRAs and that, as far as you were aware, there were no problems with that programme, were you surprised to receive this notice?
After the fire, I would have expected the fire brigade to carry out a review of what was in place. After the fire, I met with Barbara Matthews, who managed Janice Ray, and also met with Carl Stokes, the fire risk assessor, to review what had happened.
And what were the questions that you asked, first of all, Barbara Matthews, arising out of the service of this notice?
I think there were some concerns at the time about how the fire had been fought in terms of the fire brigade. We then had another 2 meetings where we talked through the door closer situation and agreed an additional budget. And we also talked through the inspection regime that was being suggested at that time.
Now, did you focus there on what the LFB had done on the night? Did the enforcement notice lead you to investigate or indeed to challenge the TMO about the adequacy of their fire risk assessments? Or what they had done?
Not specifically the fire risk assessment. I met with Carl Stokes, the fire risk assessor, and he took us through what had happened, and I was satisfied with that.
Now, if we can turn to page 4 of this notice, and you see there the table of failures identified by the LFEPA, and if we see at the bottom, in respect of Article 10, in the bottom left-hand paragraph, it says this: it was found that risk-critical items had not been properly addressed within the fire risk assessment in relation to the fitting of self-closing devices to flat entry doors and openable windows within the protected staircase. Did it not concern you that something so fundamental, something described here as risk-critical, had not been identified or addressed in the fire risk assessments?
My understanding at the time was that there was an ongoing programme of fire risk assessments, and that was picking up on issues relating to the fire doors.
Put differently, did you ever ask Carl Stokes in your discussions with him after the Adair Tower fire why risk-critical items had not been properly addressed?
I cannot recall having that specific conversation with him.
Is it likely that it didn't happen, therefore, if you cannot recall it? Can you give the panel more of assistance on that point?
Yes. If I cannot recall it, then I don't think I had that conversation, because I think I would remember it.
Beyond discussions with Barbara Matthews and Carl Stokes, what proactive steps did you yourself take in responding to the enforcement notice?
There were regular meetings with the TMO. They came back with a schedule for the works to take place. I liaised with Janice Ray on a regular basis to get updates on the works. And also we conducted the scenario testing for the emergency planning.
And did you understand at the time that further enforcement action could be taken against both the council and the TMO if the enforcement notice had not been complied with?
Yes.
Now, if we can turn to a TMO executive team meeting minutes on the 11th of February 2016, which can be found at TMO 00840 If we can go to page 2, and we go to point 3, which deals with the Adair Tower enforcement notice update, and it says, I quote, in the second paragraph, Fowler saying that the board will want reassurance from RBKC, seen by Laura and Nicholas Holgate and the fire brigade, happy with everything, protected roof as the smoke test. Robert and Barbara want clarity from the strategic part of the fire brigade. RBKC don't want to do this work if not required. Fowler reputation of RBKC and TMO. Everything to be addressed. Board may say a lot in the press about fires. Our fire risk assessments are all okay. RBKC a key partner, and we do what they want. Paper at the next board meeting will be in the open section. Can you help us understand in more detail what was meant by the phrase, quotes, RBKC don't want to do this work if not required, close quotes?
I suspect it refers to the inspection programme. Laura Johnson had asked that they go back and get legal advice and find out what was happening across London. I know that Janice was concerned around getting different levels of advice from the strategic side of the fire brigade and the operational side of the fire brigade. So we wanted to know what was happening. She would attend pan-London meetings with other officers that dealt with fire safety, and there didn't seem to be a consistent approach in terms of the inspection regime and door closures.
Did cost play an element in her consideration? Put bluntly, that RBKC didn't want to pay for the inspection programme.
If we'd have needed to pay for it, we would have paid for it. I have no doubt that we would have found that money.
Did you agree with Laura Johnson's view of this matter?
I think there was an inconsistency in advice from the fire brigade, and that needed to be clarified, and that was my experience with the leaseholder fire doors as well.
And was that a consistent or unanimous view held in the council about this point?
I can't say that it was unanimous, but it certainly was a view that Laura held and myself held.
Was it correct to say that the TMO did what RBKC wanted, as is recorded in these minutes?
We essentially commissioned them to deliver a service, so we would specify what that service would look like. In the years that I worked with them, they never refused to do anything that I asked of them.
Could we turn to the deficiency notice that was served in relation to Grenfell? Were you aware that on the 17th of November 2016, the LFB issued a notification of fire safety deficiencies in relation to Grenfell?
I do not recall being aware of that.
Now, if we can just go to it so you can see it in front of you, TMO 100-15313. Just let you briefly refresh your memory. If you'd like to go further through the letter, please do shout. But having refreshed your memory, is your evidence still that you don't recall being notified about this particular?
I don't recall being notified.
Would you routinely be notified if the TMO had received a deficiency notice or any other regulatory intervention from the LFEPA?
I think the notifications were hit and miss. Sometimes they would go to Laura, sometimes they wouldn't. I don't think we bottomed out a firm enough process in regard to this matter.
Can I just ask you this? I don't know, you may say it's not a question which you can really answer, but you accepted a moment ago that RBKC would receive enforcement notices if they were issued in relation to a particular premises. As far as you know, did RBKC ever analyse for itself the effect of the regulatory reform order to understand what it meant for the council as opposed to the TMO? Do you know?
That came in before I became responsible for the client-side monitoring. What I would say with hindsight is we did not review the MMA with reference to that order, and that was a mistake.
Yes, I see. Well, that's helpful. But I wasn't just thinking of reviewing the MMA, because I think your acceptance that the enforcement notice would come to the council as well as the TMO involves a recognition that the council had duties under the RRO. Did anyone, as far as you know, look at the RRO and to ask the question, what does this mean for the council as opposed to the TMO?
I don't think we did in sufficient detail, no.
All right, thank you very much. Sorry to interrupt you, Mr. Clear.
Thank you, sir. Could we turn to page 6 in this document? This set out a number of deficiencies that had been identified by the LFEPA. And we see, say, for example, at the bottom, Article 15.1, at the time of the audit, your procedures to be followed in the event of serious and imminent danger were inadequate. It was found that fire action notices were not displayed in the common parts. Were you aware of that particular deficiency? Was it discussed or raised by Janice Ray with you at all at any time?
I know that after this notice that plans were put in place to install the fire action notices. So it was acknowledged that that needed to be done.
Were you told that that was as a result of this notification, or was it put to you in more general terms?
No, I believed it was due to notifications, wider notifications, not just this notice.
And as a result of that, did you ask for Janice Ray to send you a complete suite of the notifications that the LFEPA had sent to the TMO, so that you were aware of the full span of the issues?
No, I was aware that they were looking at the fire notice issues.
Okay. Can you help us as to why you didn't ask Janice Ray for such a full suite of notifications from the LFEPA?
I should have asked her.
Can we now go to a joint management meeting in March 2017, and the minutes, which can be found at RBK 0003110. We can see there that you attended. You're the second identified on the list. The LFB had issued enforcement notices in respect of Adair and Hazelwood in December 2015. And if we de-amplify the document, we go to page 2. You'll see at point 5, installation of self-closing doors and annual inspection. Were you concerned at that stage that in March 2017 there were still continuing issues regarding self-closing doors?
We still needed to get clarity on the inspection process. That needed to be bottomed out.
And we see there will be a huge cost if we want to do this. Nobody has an inspection process at present, as it's not a legal requirement to have yearly checks. Could be an option to include in the fire strategy. Need to develop a programme to take to scrutiny. Liability if the doors are broken would be with the TMO. Laura agreed to hold off recommending inspections programme at present. Mm-hmm. Is it correct that it was decided at this meeting that the proposed installation of self-closing devices was to be a 5-year and not a 3-year programme?
I don't think it was this meeting. I think it was a specific meeting to discuss the Adair Tower fire.
So earlier than March 2017, you think?
I think so, yes.
Now, the last sentence there says Laura agreed to hold off recommending inspections. What was your view on the proposal to carry out annual inspections?
I think there were some practical difficulties with it that needed to be clarified, and we needed to get consistent advice from the fire brigade.
Would you have taken this decision as a decision not to proceed with an inspection programme?
No, I think it was let's find out what we need to do and then make a decision.
Now, following the meeting, Barbara Matthews emailed Laura Johnson on the 3rd of March 2017, confirming the discussion at the meeting. And if we could go to RBK 0001979. Now, you're not copied into the initial email, but you are copied into Laura Johnson's reply, which is at the top of the page. If we can look at the bottom email, which is the trigger email from Barbara Matthews, it says, Laura, just to confirm our discussion and agreement at the joint management team meeting on Wednesday, we agreed that we would have a programme of fitting of self-closers on existing flat doors if not already fitted, and refit repair self-closers if already fitted. This programme would not be over 1 year but proposes 3 to 5 years. Our recommendation is that the LFB are unlikely to accept as adequate a programme longer than 3 years, although this is yet to be proposed to them. The estimated cost for the total programme, regardless of period, is 619k. In respect of a proposed annual inspection to check, repair, replace the self-closers, you requested that we delay starting this until we have obtained further legal advice on what action we can or can't take against no access by either tenants or leaseholders. And it deals with flat door self-closers. Please let me know if I've incorrectly captured anything. In addition, please confirm that we can include in our updated fire strategy a 3-year programme for fitting of self-closers on all flat entry door. And if we go to the top of this page, we see Laura Johnson's response, and she says, I can confirm this is an accurate record of our discussion. I would like to push the installation of door closers to a 5-year programme. It will make funding the programme more manageable. Therefore, in the fire strategy, I would like it to say 5 years rather than 3. I'm not convinced of the need for an inspection programme. If we started one, then there is every likelihood it would have to be ongoing, and therefore an additional expense to the HRA indefinitely without any identifiable evidence that it impacted positively upon fire safety of residents. I understand that the conversation is not always straightforward to the LFB, and they may well push for this, but if they want to, then they need to introduce it as a London-wide standard that they will enforce against rather than on a borough-by-borough basis, and we'd make representation to the GLA accordingly. I look forward to the legal advice. Now, were you involved at all in the decision that the installation of self-closing devices should be implemented over a 5-year, not a 3-year period?
I didn't make that decision. I heard the decision being made, but that was very much Laura's decision.
Do you recall if any advice was taken from RBKC's health and safety advisor regarding the fire safety aspects of a proposal to extend the programme for 5 as opposed to 3 years?
I cannot recall that happening.
Would it have been done in such matters where examination was being applied to practicability of a fire safety measure?
I think we would have taken that advice, yes. The key point there was to get the legal advice and see what was happening across London.
Can you remember whether any of the council's own fire risk assessors were consulted on the point?
I presume that we procured those fire risk assessments externally. That would have been in the Environmental Health Department.
So it's unlikely they would have been consulted?
Yes, I think so.
Do you know whether anyone in your department or you yourself took advice from anyone as to whether the effectiveness of the fire safety measures within Grenfell or TMO stock more generally might be impaired by extending the duration of the programme from 3 to 5 years?
No.
If you needed a grant of additional money, to whom at RBKC would you have sought the money from?
We would have dealt with that within the department initially. We would have looked at the HRA, working balance, and then Laura, we would put forward a key decision if it was a significant amount of funding, and then we would make that a priority.
Can you remember at the time whether there was any discussion to seek further funds to allow the programme to be completed in 3 years as opposed to 5?
No, I don't believe there was.
Can you help us why not?
This is March 2017. I think events just took over us. The fire was about 2 months later, and I think events just took over us.
Were you aware that as a result of this email, Barbara Matthews amended the fire strategy to include a 5-year, not a 3-year?
I believe she did, yes.
Do you remember what steps you or Celia Chaliscan took to consider the impact of a delay to the programme of 5 years as opposed to 3, particularly in relation to the possibility of having failing self-closing door devices?
I think in reality I thought we would need to go with 3 and that the fire brigade would not agree to 5, so I felt that that was the direction of travel.
And would you agree that Laura Johnson fairly summarised the thrust of the meeting, or at least the thrust of her views expressed at the meeting?
Yes, yes.
Would you characterise Laura Johnson's attitude to the LFB as combative, given her concerns regarding the inconsistency in strategic advice given by the LFB on this issue?
I would say frustration.
Did you question or challenge Laura Johnson's decision on this at any stage?
No.
Can you recall whether the meeting and this decision was reported to the Housing and Property Scrutiny Committee?
I cannot recall.
Is it
I don't-
likely, probable, unlikely, improbable?
I would have expected Laura to have discussed this with Councillor Feilding-Mellen, and we did keep him regularly updated about the outcomes from the Adair fire.
Now, if we could go back to your first witness statement, which can be found at RBK 000-33719/32, and paragraph 158, you said this, and I quote, "Inspection of self-closers was very difficult. We were told by the TMO that residents were removing or disabling the self-closers, possibly because they were annoyed by them. It was almost impossible to monitor or inspect this regularly. The tenant might have disconnected or reconnected the closers between visits, so this could not be continuously monitored and would have been very resource intensive." Do you agree that while it was not possible continuously to monitor, there was an obligation on RBKC to carry out regular inspections, or at least to use reasonable endeavours to carry out regular inspections?
Yes.
Ultimately, looking at what you said here, is the reality that it was the cost of an inspection programme as opposed to anything else that was the fundamental concern here?
I think it was the practicalities of getting access.
But bearing in mind Laura Johnson's comments about the indefinite burden on the HRA account, cost was certainly a factor, wasn't it, at the very least?
Laura would... It was an issue, but we would never not do something because it costs too much if it was about resident safety.
Could we turn to a separate topic now, which is audits, and if we could stay within this statement but go to paragraph 50 on page 9. You say there, the annual performance agreement provided for a list of audits which took place annually. The results would give a summary of the audit findings and the scoring every year. Audits were carried out by our internal audit department, which is part of corporate rather than housing. Why were audits carried out by corporate rather than housing?
Because I think it was seen as being independent. That's the way it had always been established since I'd worked at the council. I don't think it was ever questioned.
But you'd always received the audit reports?
Absolutely, yes.
Now, could I ask you to go to RBK 000-30149? Now, this is the report on our TMO performance for 2011-2012. The performance agreement is at Appendix 2 and can be found at page 21. There we go. And if we could go over the page to paragraph 3.4. Where we have the title Audits, and there's a table setting out the draft audit programme. Was that a list of internal TMO audits or audits to be performed by RBKC?
Yes, it was internal TMO audits that would be performed by the audit department.
Now we can see towards the bottom end of this table the heading HR and Organisational Development, and that contained a second box which was entitled Fire Risk Assessments. Were you aware of any audit in relation to FRAs ever taking place?
I would have been aware of that at the time.
We can't find anything. I was wondering whether you could shed any light on whether the audit ever took place.
Sometimes audits slipped and moved into another year. I cannot recall this specifically.
Okay.
I'm sorry.
Let's see if we go on further through the reports, we may get clarity. But if we could go to the fire risk management system for 2013 and the audit that RBKC carried out, and if we look at RBK 000-0313. Now there you go, the RBKC final audit report, TMO Health and Safety, dated April 2013. The title page stated that the final version was circulated to Laura Johnson and Robert Black. Did you receive this document?
Yes.
What did you understand the purpose of the audit to be?
To look into the operating procedures of the TMO, and the audit would look at how the policies and procedures were being implemented, would look at compliance issues. In this case, it got limited assurance.
Thank you.
So it was a poor audit.
And we'll go on to the underlying reasons for that. But if we could turn to page 4 in this document. Did you note when reading it that it identified in the third bullet point of paragraph 9 as a high priority that quotes, all portable firefighting equipment should be regularly inspected by the appointed contractor and any fault equipment identified replaced on a prompt basis?
Yes, I can recall that there'd been a problem with the checking on the fire extinguishers.
And turning next to paragraph 10 and the 5th bullet point there, a medium priority was that, quote, appropriate performance indicators relating to health and safety inspections should be developed by management. Presumably you noted that as well.
Yes, and they did develop them for their internal use.
And just flowing from the answer you gave earlier on, we see at paragraph 11 that the audit gave a limited assurance.
Yes.
Did it concern you at the time that that was the result of this audit?
Yes, I saw the action plan follow up in September of that year, and I could see that action was being taken to address those areas. A lot of it was to do with documentation in terms of recording compliance on the Keystone system.
And did you discuss your concerns and the reasons why a limited assurance had only been given with anyone at the TMO?
I cannot recall at that particular time. We would have picked it up through the performance review.
Now, if we can go to section 8 in this document, which is at page 18, and that deals specifically with fire safety. And if we go to paragraph 8.3 on page 19, the report says the audit examined 3 fire risk assessment reports as follows: Dacre House, 31 Danvers Street, and Downing House. Were you aware that in reviewing just 3 fire risk assessments, the audit wasn't a comprehensive review of the TMO's FRA arrangements?
I would agree with hindsight, yes.
Were you aware of that at the time? Can you remember?
I cannot recall, sorry.
Did you ever ask for there to be a comprehensive review of the TMO's fire risk assessment arrangements?
We did work with them in the around 2009-2010 to look at their arrangements, which led to the procurement of an external fire risk assessor.
Now, can we turn to section 9 of this report, which is over the page on page 20, and it's concerned with management information and budgetary control. There we go, and if we can turn over the page to para 9.4, where the recommendation is emboldened. Appropriate performance indicators relating to health and safety inspections should be developed by management. This ensures that inspections can be monitored and any performance issues identified for appropriate corrective action to be taken where performance does not meet expectations. What steps did you take to ensure that the recommendation had been implemented by management of the TMO?
I saw through the action plan follow-up that they'd implemented those KPIs. I would also have expected the audit department to check up on the following actions.
Looking at the substance of the management response, did you endorse management's acceptance of the need for KPIs specifically monitoring fire risk assessment, enforcement deficiency notices received, fires, percentage of compliance on maintenance of fire equipment?
Yes, I think the problem was that we didn't collect enough compliance performance indicators at a high level when monitoring the TMO.
Were you aware that a suite of performance indicators, including fire safety specifically, were not introduced by the TMO until January 2016?
I cannot recall that. I understood that they'd done that earlier.
And on what was the basis of your understanding that they'd done that earlier?
Just on feedback through the performance agreement and through feedback on the audit action plan.
And those were the matters upon which you relied in reaching that view.
Mm-hmm.
Now, a follow-up audit was conducted in December 2013, which can be found at RBK 0000320. Now, based on what you've just said, were you aware that a follow-up audit had been conducted in December 2013?
Yes, I thought it had been conducted in September. Probably this is the date of the report.
Did you read this follow-up audit report?
If it had come to me, then I would have read it. I cannot recall specifically reading it.
Do you recall that the overall assurance level had increased by 1 to satisfactory?
Yes, I know that they'd made improvements.
Now, that had been, we can go to it if need to be, but we don't think we need. Satisfactory assurance is defined as, whilst there is a basically sound system, there are some weaknesses and or omissions which put some of the system, unit, process, etc. objective at risk. Were you yourself satisfied that the TMO's health and safety arrangements were now satisfactory?
I thought they were making progress to address the recommendations from the audit plan.
That's not necessarily an answer to the question I asked. Were you satisfied as a result of this follow-up audit that the TMO's health and safety arrangements were satisfactory?
I cannot recall specifically.
Do you recall any ongoing concerns following this report about the adequacy of the arrangements the TMO had in place for the management of health and safety?
No.
Did you follow up any of the specific points set out in this report?
I know that I looked at the follow-up action plan and the tasks were being taken forward.
Can we now turn to a separate and distinct topic, which is that of vulnerable residents and personal emergency evacuation plans? Did you know whether the TMO had a system for recording the vulnerabilities of residents and disabilities as well?
I met with the TMO and the London Fire Brigade about PEEPs, and we agreed that was when a letter came up from the Fire Brigade around PEEPs in care homes and sheltered housing, and it was agreed with the Fire Brigade that we would concentrate on doing the PEEPs for people living in sheltered housing, and that was in 2016.
Were you a participant in those discussions?
Yes, I was.
Who represented the LFB?
I cannot recall. It was the policy side of the LFB.
Was it someone from LFB headquarters, or was it someone from from the Borough Commanders Division?
I think it would have been from the Borough Commanders Division.
Was the result of that conclusion recorded in writing, whether in a minute or in correspondence?
I cannot. I've looked and I cannot find anything.
Did you know whether the TMO had a system to devise PEEPs for disabled and vulnerable residents to evacuate?
They did. They did for sheltered housing. Yes.
Did you ever ask why there were no such arrangements for general needs housing?
It was very difficult to kind of clarify who had vulnerabilities in our housing. People might have moved in 20 years ago and their needs may have changed. The TMO, we did a tenancy audit back in 2005, I believe, and the TMO were in the process of doing another tenancy audit where they would try and pick up on that information.
Were you satisfied as to the adequacy of those measures to ensure the TMO captured as up-to-date information regarding disabilities and vulnerabilities as was reasonably practicable?
I think they were trying their best. I think it was a challenge for them.
Whose role was it at RBKC to monitor or scrutinise the adequacy of provision for evacuation of vulnerable and disabled in the event of a fire?
It was no one's specific responsibility.
Did anyone in your team take proactive steps to satisfy themselves or to assess the adequacy of the provision to meet the needs of the disabled and vulnerable residents in the event of a fire?
No.
Can you help us as to why not?
I think, having met with the fire brigade, my understanding is that we'd concentrate on the sheltered housing, and if anyone came across as vulnerable, then Janice would be notified and then she was do a PEEP. We hadn't agreed to to whole-scale programme, and I knew that they were doing the tenancy audit to try and capture information.
Now, in relation to that meeting with the LFB that you've gone back to, was that decision reached as a result of a proposal to limit PEEPs to sheltered housing made by you or the TMO?
It was linked to a letter which said PEEPs in relation to care homes and sheltered housing. So it didn't talk about general needs stock. It talked about specialised housing.
Did you ask for the LFB's views as to the need for and the practicabilities of preparing PEEPs for general needs housing?
I don't think we focused on that in the discussion. I think it was around the sheltered.
Now, if the prompt for that meeting was confined to sheltered housing only, that isn't of itself a justification for not considering PEEPs in general housing, is it?
No.
Did consideration of PEEPs in relation to sheltered housing prompt in any way any consideration of the need for PEEPs for general needs housing?
We needed to understand the profile of our residents, so that was linked into the tenancy audit that the TMO were doing, and then I would expect them to come forward with recommendations.
Did they ever do so?
Not by the time of the fire, no.
And you said this meeting was in 2016.
Yes.
Can you remember when in 2016?
I think it was halfway through the year.
So your evidence is after a year, the TMO still hadn't come back to you with proposals for PEEPs for sheltered housing?
No, they did. They agreed they would do PEEPs for sheltered housing. The discussion had not been on general needs.
Now, can we go to RBK 000-53614, which is an email chain between Jean Dainteith, Robert Black, Laura Johnson and yourself. And if we can go to page 2 of that chain, where you can see at the bottom, Jean Dainteith forwarded an article at 14:42 on the 28th of September 2010 to Robert Black and Brian Deans, who's from the LFB. Robert Black responded at 12:20 on the 30th of September, which is the bottom of page 1. He says in the second substantive paragraph, I feel it is worth reiterating that as we have now completed the fire risk assessments on all of our potentially high risk, which includes all of our high risk blocks, and in each case evacuation strategy has been confirmed as being stay put, defend, in place. Were you familiar with the concept of stay put?
Yes.
Did you ever question the assertion that stay put was the appropriate strategy for the TMO housing stock?
No.
Now, the email continues in a third paragraph thus, however, with regard to emergency procedures for disabled residents, we are aiming to produce PEEPs. Were you familiar at that time, so September 2010, with the concept of PEEPs?
I don't think I was. I just returned back to work and taken on responsibility for the TMO clienting around that time.
Can you help us, given your lack of familiarity, what research you carried out so that you understood more about PEEPs and the circumstances in which they were required?
I was familiar with the concept. I'd worked in supported housing for many years where we kept lists of vulnerable people in the event of an evacuation. So I was quite clear about the concept.
And in your previous employments, had PEEPs been confined to those in sheltered housing, or were they provided for both sheltered and general needs?
I worked in specialist housing, so hostels, supported housing, refuges. So it wasn't a particular complex. It would just be a list of vulnerable residents. So it was specialist housing.
Now, if we can stay on this page but go up, because Laura Johnson forwarded this email correspondence to you at 16:40 on the 30th of September 2010, and she said this: when the TMO have put this into action, it would be good if we could get Janice Ray at the TMO to inform the other RSLs, that's registered social landlords, at the Homes and Housing Group, of what must be best practice in assessing the needs of disabled residents and planning with them what to do in the event of a fire. You forwarded the email to Celia Chaliscan at 9:46 on the 12th of October, saying FYI. Sorry.
I would have expected Celia to put it forward on the agenda for the Homes and Housing Group.
Following this email chain in the last quarter of 2010, did you ever check whether the TMO had put in place the suggested approach to vulnerable residents?
I cannot recall.
Do you remember chasing Celia Chaliscan about it?
I cannot remember.
Did you speak to Janice Ray about the proposal that was described as best practice?
My memory is gone on this one, I'm afraid. If there's no follow-up in an email from me, then I suspect not.
If it wasn't followed up, would you accept that that was a failure of oversight on the
Ye-
part of RBKC?
Yes.
Now, if we could go to RBK 000-53712. Now, this is an email from Claire Wise to you and Celia Chaliscan on the 26th of September 2012, entitled Meeting with the London Fire Brigade HQ. Now, Claire Wise explained that she and Janice Ray met the LFB that morning. I'll just let you briefly refresh your memory of that email. And then I'll ask the question, do you remember receiving it?
I remember there was a specific issue where the fire brigade came to the council and requested that all sheltered housing, so not just council stock, had arrangements in place to evacuate their buildings. It wasn't just council stock, it was all sheltered housing in the borough.
And if we could go to the fourth paragraph of this email, which starts with the words, they believe, it's further down the page. And it says this, and I quote, they believe that it is the person, organisation who manages the building that has a duty to develop a plan with actions to be taken in the event of a fire and collect information on residents with additional needs, i.e. it is the responsibility of the landlord building manager to establish the needs of residents, though it is acknowledged that residents are able to decline to disclose this information if they choose. Did receiving this email lead you to make any further inquiries into how the TMO collected data on vulnerable residents?
I cannot recall at that time. It was an ongoing conversation with the fire brigade about all sheltered housing in the borough. I don't think it actually was concluded with a firm decision.
Can you remember whether you made any inquiries of Janice Ray, to whom this email was copied?
I cannot recall, sorry.
Did you conclude after considering this email that the question of Pepys was a matter that ought to be the subject of close scrutiny by RBKC, given the LFB's interest?
I think the fact that we couldn't get clarity from the fire brigade meant that we didn't take this forward.
Well, looking at the paragraph I've just quoted to you, the one which starts, they believe, what is uncertain about the message summarised in that paragraph?
I think, again, it was not just around our stock, it was around all housing association stock in the borough. And I think people thought that this wasn't practical to manage. And this conversation kind of didn't really go anywhere after this initial meeting.
Given your evidence that you considered the message to be inconsistent or some way unclear, did you ever email anyone at RBKC or the LFB saying the message is unclear and setting out the practical issues about which you had concern?
I cannot recall doing that. Claire was very much involved in those discussions.
Now, can we turn to RBK 000-46334, which is another email chain, this time between you, Laura Johnson, and Janice Ray. On the 11th of April 2016, Laura Johnson forwarded a letter from the LFB to you and suggested that you should arrange a meeting with Janice Ray regarding its concerns. Now, if we can go to that letter, it's RBK 000-46333. Now, the letter is dated the 5th of April 2015, i.e. a year before the email under which it was forwarded to you, and it's entitled Care Homes and Specialised Housing, Tenants and Service Users with Vulnerabilities or Dependencies, Protection from Fire and Prevention of Future Deaths. And if we go to the second page, you'll see there the heading Evacuation Strategy and Compartmentation Separation. And it says this: The LFB have experienced a number of fires where breaches of fire compartments have resulted in the rapid and unexpected spread of fire throughout buildings, which has compromised the evacuation strategy. Often this has been via hidden voids, utility and ductwork penetration, and false ceilings. When this happens, there is obviously an increased risk for those within the premises, especially for those considered to be more vulnerable. The integrity of compartmentation and separation within your premises is therefore critical to the evacuation strategy. Now, that letter expressly concerns care homes and sheltered housing. However, did its receipt prompt you to consider the question of how the TMO was taking into account vulnerabilities in general needs housing?
No.
So April 2016.
No, this is the letter.
I was about to ask you, is this the letter that prompted?
This is the letter that prompted us to meet with the fire brigade.
And did you consult Janice Ray about the contents of this letter before you met the LFB?
Yes.
And did you press her and seek further information on the substance of the arrangements the TMO had for ascertaining sufficient information on vulnerable residents?
When we met with the fire brigade, we agreed that we would complete PEEPs. Hash Chantroon was there, that's responsible for supported housing, who would have overseen that process, working with Janice.
Now, can we turn to another email chain, TMO 00853 which is an email of the 23rd of March 2017 from Christine Cummings to you concerning various issues raised in relation to flats 6 and 7 at Grenfell Tower. And the issues that were escalated to you as a number of emails had been sent to officers of the TMO without any action being taken. And the email notes, nearly every time Kathy has attended the property, either one or both lifts have been out of order. The doors to both these properties are too heavy and outside the recommended range. The fire door is too heavy and the doors not closed properly. There we go. I'll just let you refresh your memory, Miss Johnson.
I can remember this.
That's the answer to my first question. You remember it?
Yes.
Oh. Can you remember what action you took in response?
I went to Sasha Jevons, who was the exec director for housing, to see if the matter could be resolved.
Now, did this complaint prompt any concerns in your mind about how the TMO were managing the risks that were particular to vulnerable residents in the event of a fire?
I know that heavy fire doors can be an issue in housing, and that you need to strike a balance between making sure the fire door is safe and secure and the needs of the residents. So I'm familiar with it being a problem. I asked Sasha to intervene because we weren't getting anywhere with the managers. I cannot recall what the outcome was, but I do remember this issue.
Now, could I ask you, before we leave the topic of PEEPs, to go to TMO 008405883, which is the 2016 Health and Safety Report. If we go to page 18, there we go, and if the last paragraph of 15.2, which starts, whilst this will continue to be an area of potential risk for the KC TMO and residents, we are committed to close liaison with the LFB and RBKC to implement initiatives which will enhance resident safety swiftly and effectively. Additionally, it is important that we continue to provide residents with fire safety information, advice, guidance, publicise fire procedures on the website and the residents' handbook, articles and the link, etc., and identify residents with special needs and, when necessary, work with them to draft a specific PEEP to ensure that their safety is protected. Do you recall receiving this report and reading it?
I cannot recall it specifically, but I know that the TMO were working towards doing PEEPs where they had identified vulnerable residents.
And would you agree that here the work on PEEPs is not limited to sheltered housing, but appears to be across the estate.
When we met with the fire brigade, we agreed that if any vulnerable residents are identified to the TMO, then they would do a PEEP.
Now, if we can turn to a separate topic, which is complaints, and in particular complaints KPIs, could I ask you to turn back to the TMO Performance Report 2011-2012, and in particular Appendix A. Now, this can be found at RBK 000-30149/16. And here we have, it's called the PI, Performance Indicator Table. And we see that there appears to be no KPI in relation to complaints. Is that a fair observation?
Yes.
Can we turn to the performance report for 2012-2013, which is at TMO 100-39245/18. Again, would you agree that there appears to be no KPI in relation to complaints?
No.
Can you help us to why there were no KPIs for complaints in these years?
We should have had a complaints KPI. It shouldn't have been excluded.
Can you help us as to why complaints weren't addressed, though?
I cannot recall. We had complaints as a regular agenda item at the HRA meeting. I know we discussed complaints with them. John Morecambe, who reported to me at the time, would liaise with the TMO on complaints. This is an omission that shouldn't have happened.
And you can't explain, given that degree of consideration, why it didn't transform itself into a KPI?
I cannot recall why this was excluded.
Now, can we stay in this document but go down to page 22? And you'll see there in 3.2, new KPIs. There's a new KPI in relation to complaints. You see that's the first bullet point on the right-hand side.
Yeah.
And if we go to page 29, we can see this is included HS12. There we go. Complaints. Number of TMO stage 1 complaints answered within target. Now, you say at paragraph 46 of your first statement, and we don't need to go to it unless you'd like me to take you there, you refer to a year in which the number of complaints being handled by the TMO increased. Was the complaints KPI introduced as a result of that increase?
No, I think it was just introduced in order to collect that information.
Now, do you agree that the KPI relates solely to stage 1?
Yes.
And do you agree that the KPI would have told RBKC nothing about the adequacy of the response to the complaint?
Yes.
Equally, it would tell RBKC nothing about the resident's satisfaction with the response.
Yes.
Why did the KPI not relate to stages 2 and 3?
We should have looked at that. We should have looked at complaints KPIs in more detail.
And if that detail had been provided, it would have given RBKC more detailed and hopefully better knowledge of the effectiveness of the complaints system the TMO was operating.
Yes, it would have.
Now, could we now go to TMO 1000946? Now, this is a report on Kensington Chelsea Tenant Management Organisation's Performance Review 2014-15 and Performance Agreement 2015-16. And if we go to page 7, and if that could be expanded, you see HS12 there, just below HS7, and it says target met, and a green traffic light given. And if we go first, bearing that in mind, now go down to page 19. If that could be amplified. And HS12 has been removed. Can you help us to why HS12 was removed?
I've thought about this a lot and I can't recall why it was removed. It shouldn't have been removed.
But you accept it was?
Yes.
Can you remember why? Well, first of all, did you ever identify that point at the time and say there ought to be a KPI concerned with complaints and covered in more detail?
I should have done.
But you didn't. Did anyone?
No, it wasn't raised as an issue.
Can you help the panel? What was the degree of oversight that your department had over the ways and means in which the TMO collected and recorded data regarding complaints?
They had their own systems that were separate to the council.
In your time, did RBKC ever inspect or indeed audit the TMO's complaints process?
I believe the audit department audited the complaints process.
And that would have included a review of the records, would it?
It should have, yes.
Were you aware of the fact that complaints made through a councillor were often recorded as member inquiries?
Yes.
So didn't feature in complaints data?
Yes.
Did you ask for information as to how many member inquiries had been made and the substance of them?
John Morecambe would do an annual report where he would set out the number of member inquiries and what they related to, as well as complaints.
And would that report draw out the themes, if any, emerging from the complaints information?
Yes, it would.
Did you ever ask for details on the TMO's classification of complaints and concerns?
No.
Can you help us as to why not?
A lot of the complaints were around repairs, failure to attend appointments. There was nothing that kind of stuck out as unexpected in terms of their complaints.
Now,
They would come to me on complaints by exception if there was a particular problem.
Now, just one final question before I ask the panel to rise for the morning break. Could I ask you to go to RBK 000-46165, which is an email chain from January 2015 between you, Peter Madison, Roger Keane and the GTLA. Now, that email chain begins with the GTLA sending a complaint in relation to the improvement works on the extraction and ventilation system and following up on an email sent to Councillor Feilding-Mellen. And you forward this to Peter Madison. And you say, Peter, when we receive these type of email before, we channel them through the TMO's complaints process as a means of managing this and suggest we do so again. There we go. Peter Madison then proposed that the GTLA's email be treated as a member's inquiry rather than under the TMO complaints procedure. If we go back to where we were, at the top. And you basically say, there we go, happy with this approach, or with that approach, I should say. What did you understand at the time to be the distinction to be made between a member's inquiry and a complaint?
There was a formal complaints process that the TMO had in place, where you would go to the complaints team and make your complaint, and then there would be a formal investigation. Members, councillors would often email officers directly, and that would include officers at the TMO with inquiries, and often they got treated as a member's inquiry rather than a complaint. I had some concerns with this because there was repeat emails from Tunde about concerns. So I think at one point they did put it through the complaints process.
Can you help it? Because that was going to be my next question. At the time, on what basis were you satisfied that the members' inquiry approach was the appropriate one as opposed to channeling it via the complaints process?
Because Peter was often in direct contact with Councillor Blakeman and would email her directly, and you would also get a quicker response rather than go through the complaints process, which was a 15-day turnaround time.
And was it ever a cause of concern either on your part or anyone else at RBKC that the members' inquiry route may have resulted, and using that route, may have resulted in under-reporting of the volume of complaints being made by residents?
I think we didn't capture the information systematically. So especially where it was officers responding to councillors directly.
In your view, do you think the data
The
did
data
result in an under-reporting of complaints?
it could have done. John certainly would have kept. John may not have known about all the members' inquiries. He may not have been party to all of those. So I think there was a lack of systematic reporting, yes.
Do you think there was a lack of systematic under-reporting specifically in relation to Grenfell?
No,
And why do you say that?
because I would, whenever an email came in, I would always check that it had been responded to.
Thank you. Sir, I somewhat peremptorily suggested when the time for the mid-morning break might be, but this would be a convenient time.
Well, if it's convenient to you, I think it's a good time to take it, yes. We'll have a break now, Ms Johnson. We'll come back at 25 to 12, please. And again, please don't talk to anyone about your evidence when they're out of the room. Right, 25 to 12, please.
Thanks, sir.
Okay. Yes, would you ask Mr Johnson to come back in, please? Thank you. Right, Mr Johnson,
Yes.
ready to carry on? Good. Yes, Mr Kinnear.
Thanks, sir. Could we turn to paragraph 181 of your first witness statement, which is RBK 000-33719/36? Thank you. In paragraph 181. And you say in the last sentence at the bottom of that page, I remember seeing an upturn in the number of complaints coming forward via the TMO. However, we were told this was because the complaints process had been relaunched, quotes, and the TMO were reaching out to more residents. Who told you that the complaints process had been, quotes, relaunched, close quotes?
Yvonne Birch.
Did you seek further details from the TMO as to how they were, quotes, reaching out, close quotes, to more residents and the success of that initiative?
They'd published the complaints procedure. I think they'd reviewed the procedure and they published it, and obviously it would go in the Link magazine and things like that.
Do you think it was linked to the publication by the TMO of a new complaints policy in September 2015?
I believe it was.
If we could look at that updated complaints policy, which can be found at TMO 00837246. Do you recognise that document? We can go on to the next page if...
Yes.
Were you ever given a copy?
I don't know that I had a copy of it. Definitely I had a copy of it.
Did you ask Yvonne Birch or indeed anyone else what the major changes were in this new version of the policy published in September 2015?
I cannot recall.
Did you seek a detailed explanation from Yvonne Birch or indeed anyone else at the TMO as to how and why the relaunch had resulted in a greater number of complaints?
My understanding was they just promoted it more publicly. I think at the time as well there'd also been issues with the customer service centre, and there'd been some retraining of staff, and that had sparked an increase in complaints as well.
Did you, or indeed anyone else at RBKC, to your knowledge, seek any information about the nature of the complaints being made in order to verify whether there were any trends or patterns which might give rise to TMO operations?
We didn't look at that granular detail, which was a mistake.
Would it be fair to say, therefore, that you took at face value the assurance that it was the relaunch that had produced the
Yes.
uptick in complaints?
Yes.
Now can I turn to the question of board review, and if we could go back to your first witness statement, and which is at RBK 000-33719/38 and paragraph 190.
Mr Kinnear, I'm sorry to interrupt you, but my transcript is not scrolling, and I don't know whether other people's transcripts are scrolling or not. Is yours?
Mine is. Nods from round in the body of the hearing. There's
I thought I'd been singled out for special treatment, but not, because Ms Estefan says neither. All right, well, I suggest we carry on, and we'll see how we get on.
Sir, thank you. Looking at paragraph 190, you say there that you recalled a petition from Grenfell residents being presented to the scrutiny committee, and that resulted in a review by the TMO board. If I can go now to TMO 100-11591. Now, as you see, these are minutes of a joint meeting between the council and the TMO. We can see from the very top that you attended. If we could go to page 2 of these minutes, and in particular the bottom section, and in that very final paragraph, which starts with the words Councillor Blakeman, also presented a petition with 60 signatures about our management at Grenfell and compensation for residents. Amanda Johnson feels that it is a conflict of interest for Councillor Blakeman, as she is a council-appointed TMO board member. Fowler suggested that Amanda Johnson speaks to Laverne about this, as it needs to be urgently addressed. First of all, what was the conflict of interest that you identified?
It wasn't just me that had identified it, it was Fowler, the company secretary, as well. Councillor Blakeman was a member of the TMO board, but also a member of the Housing and Scrutiny Committee. So that's where the conflict of interest came from. So I agreed to go and get some advice, and I got that advice, and there was no conflict of interest.
Would you accept that there could have been no conflict of interest for Councillor Blakeman to represent the interests of the residents if the TMO existed to serve
Yes.
the interests of those residents?
Yes.
Now, Ms Johnson, that concludes my prepared questions for now. Sir, might I have a break of, say, 10, 15 minutes?
Shall we say till midday?
Thank you, sir.
And then we'll see where you stand.
I'm grateful.
Ms Johnson, at this stage, when Council says he's finished asking the questions he's prepared, we have to have a break just to make sure nothing's been overlooked and to allow questions from others who are not in the room to be considered. So we'll break now until 12 o'clock. And then when you come back, we'll see if there are more questions for you.
Okay,
All right?
thank you.
So, and please don't talk to anyone about your evidence while you're out of the room. And then if you'd like to go with the usher, that will be fine.
Okay,
All right? Thank you. Right, midday then. Thank you so much. Yes, would you ask Mrs Johnson to come back in, please? Right, Mrs Johnson, well, we'll see whether there are any more questions for you.
Okay.
Yes, Mr Kinnear.
Just a few, sir. In your evidence this morning, you emphasised the difficulties of collecting information regarding the vulnerabilities of residents. At the beginning of a tenancy, what system was in place for RBKC's housing department to share information with a new tenant about their vulnerabilities?
If they've made a homeless application, we would have information about vulnerabilities on the IBS system. That could be shared with the TMO.
And was it shared with the TMO?
It should have been shared with the TMO, yes.
What procedure was in place for adult social care to alert RBKC and or the TMO of a resident receiving a new care package or their care package changing because of a change in need?
There was no mechanism.
Do you know why?
I think there would have been personal data issues. We would have needed an information sharing agreement with the TMO. I don't think that was ever put in place.
Was it ever considered, Ms Johnson, an information sharing agreement?
Yes, we've considered this.
And was it under regular consideration during your time, or can you give the panel particular dates or a date when it was considered?
I can't recall a particular day. I mean, as well, I would act as a conduit between the council and the TMO. So people would come to me if they had concerns about a resident, and then I could initiate something with the TMO.
And was the information sharing agreement not pursued because of the data protection issues that you've referred to earlier on?
I think it was an obstacle that got in the way.
If a resident applied to RBKC for a transfer as a result of a change in need, would RBKC inform the TMO?
Yes, we'd have to.
And in the context of PEEPs, what did you yourself consider to amount to a vulnerability? Was there a working shared definition applied by both RBKC and TMO?
I don't think there's a strict definition. It could be anything from physical disability to mental health issues to mobility issues. It could be any one of those things.
Was there ever a shared definition with the TMO? Would you sing from the same hymn sheet?
I think we would recognise vulnerable people in the same way, yes.
Is that saying that you didn't have a shared?
No, not a definition, no.
Now, finally, could I ask you to go to RBK 000 Just a brief question in relation to this. I'll let you refresh your memory.
Can you just tell us what this document is?
I think it's from the regeneration team.
Are you familiar with it?
I don't recall it.
No. Would you know who would have written it?
I would be guessing, but I think it's a regeneration document.
And Laura Johnson, when we asked her about it, she didn't recall who wrote it. Would it help? It obviously refers to Silchester Garages and the Trellick consultation. Does that help you as to who might have written it and for what purpose? You'll see in the concerns of using the KCTMO, the 2 bullet points there, decanting of garages at Silchester and consultation at Trellick. Does that help you?
It would be either Ruth Angel, I think, or Kitty Mortimer.
And were they in regeneration?
Yes.
Ms Johnson, I have no further questions for you, save to ask, is there anything else which you haven't said, which you'd like to say to the panel?
I'd like to say I fully recognise that we should have had more scrutiny and more technical skills in my team to oversee compliance, and I fully accept that. I grew up in council housing, and I've seen its demise since the 1980s when Right to Buy was brought in. There's been deregulation in the sector. There's a lack of investment going into council housing. And I hope that you will look at this in a wider context. The government reduced rents for 3 consecutive years, which reduced funding. Sale of high-value voids, which is no longer happening, and we couldn't borrow more money to invest in our stock until after the fire. So I think that there are wider issues here through successive governments, Tory, Labour and the coalition. Council housing is a really important community asset that should be valued.
Ms Johnson, thank you very much for coming to give evidence. It's much appreciated.
And can I just say, I'm so sorry. I'd do anything for it to not have happened. There isn't an hour that goes by that I don't think about it.
Well, Mr. Johnson, we are all very grateful to you for coming to give your evidence. I'd like you to know that we've all found it very helpful to hear from you, and it really has been a benefit to us.
Thank you.
So we are very grateful indeed.
Thank you.
All right, thank you very much. Would you like to go with the usher then, now, please? Thank you. Yes, Mr. Kinnear, thank you very much. We have another witness waiting, I believe. Is that right?
You do, sir. The next witness is Feilding-Mellen, who will be examined by Mr Millet.
Yes.
We would ask you to rise, however, momentarily to allow the usual
arrangements to be made.
Please, sir.
I quite understand that. Well, we'll rise now, and you've been asked the usher to come and get us when the arrangements have been made.
Will do, sir.
Right?
Thank you.
Thank you very much. Yes, Mr. Millett.
Good afternoon, Mr. Chairman. Good afternoon, members of the panel. I now call Mr. Rock Feilding-Mellen, please.
Good morning, Mr. Feilding-Mellen. I understand that you wish to make the affirmation.
Yes.
Thank you very much. Well, then would you read the words on the screen, please?
I do solemnly, sincerely, and truly declare and affirm that the evidence I shall give shall be the truth, the whole truth, and nothing but the truth.
Thank you very much. Now do sit down and make yourself comfortable. When you're ready, Mr. Millett.
Right, thank you very much, Mr. Chairman. Mr. Feilding-Mellen, can I start by thanking you very much for coming to the inquiry and assisting us with our investigations? We're very grateful to you.
Of course.
If you have any difficulty understanding any of my questions, I can put the question in a different way, or I can repeat the question. Just say, if you feel you need a break at any time, we can take a break. We will be taking scheduled breaks during your evidence. The first one will be during the course of the afternoon after lunch. The other thing I would ask you to do, please, is to keep your voice up so that the transcriber who sits to your right can get down accurately what you're saying. Try not to nod or shake your head. Say yes or no, as the case may be,
Okay.
because silent gestures don't go onto the transcript. Now, you've made 2 witness statements to the inquiry, plus a statement to the Metropolitan Police. The questions I'm going to ask you are based on your inquiry statements, which I'll put to you first, please, formally. The first one is RBK 3033403. It's dated the 18th of October 2018. That's its first page. Is that your first witness statement?
Yes.
And if you go to page 41, please, you'll see the date and a signature. Is that your signature?
It is.
And I'll call that your first witness statement. Can I show you RBK 30054433, your second statement, please? Is that the first page of your second statement?
Yes.
Could we go to page 8, please? We can see a signature there. Is that your signature above the date 26th September 2019?
Yes.
Have you read each of these statements recently?
Yes.
Can I ask you to go to your first statement, please? Page 5. And I'd like to look with you, please, at paragraph 18, where you say this. During my time on the council, I performed a variety of these roles. As a backbencher, I sat on the Public Realm Scrutiny Committee between 2006 and 10, and then on the Housing and Property Scrutiny Committee between 2010 and 2011. And I sat on the Planning Committee between 2006 and 2011. In fact, I think it's right that the second statement there, that you sat on the Housing and Property Scrutiny Committee between 2010 and 11 is wrong. Is that the case?
That is the case. I did spot that and informed my lawyer that that should have been the Cabinet and Corporate Services Scrutiny Committee that I sat on during those dates.
Right. Is it correct that in your role as Cabinet Member for Housing, Property and Regeneration, you would attend meetings of the Housing Property Scrutiny Committee?
Yes, I was invited by the committee to attend. I was not a member, but I did attend between 2013 and 2017 when I was in that cabinet position.
Did you attend the Housing and Property Scrutiny Committee before 2013?
Not that I remember doing so, no.
Are you able to assist us with how that error crept into paragraph 18 of your statement?
I think it's because I was writing and thinking about the Housing and Property Scrutiny Committee so much during the writing of this statement that I just made that mistake.
Right. And you first realised that in April, I think, this year.
When I started rereading this statement in preparation for this, yes.
Apart from the correction that you've just made to your first statement, are the contents of your first and second statements true?
I have reread them, especially in the light of spotting that mistake, and as far as I am aware now, they are true.
Thank you. Have you discussed your statements or your evidence that you're going to give today with anybody before coming here?
I've discussed my statement with my lawyers, with the council's lawyers.
I see. Now, I'm going to begin substantive questions to you by asking you some questions about your background and a bit about your training. You became a councillor for or at RBKC in, I think, 2006, didn't you?
Yes,
And that was in the St Charles ward.
correct.
And then from July 2010, you were councillor in the Holland ward, I believe.
That's
Is that
correct.
right?
Yes.
Yes. And in each case, was that as a Conservative councillor?
Yes.
And in May 2006, is it right that you had just turned 27 years of age?
That is correct.
What was your career and background before 2006?
After I finished doing a master's at the LSE, I started my own business in property investment.
And what was your master? What was the subject matter of your master's at the LSE?
It was international political economy.
Right. And is it right that from 2009 you were, and I think remain, the director of a company called Socially Conscious Capital Limited?
That's correct.
Is that a property development and investment company?
It is in the property industry. It is what they call a strategic land promoter, whereby we seek to get planning permission on greenfield sites around towns and villages in the UK.
So you're involved and have been since that time involved in major regeneration or perhaps minor regeneration projects?
It's all to do with the planning. We don't do any building work, just getting the planning permissions.
And is that specifically in social housing or?
No, it's mainly residential, but mixed tenure.
Mixed tenure. Were you involved in that business in parallel to your carrying out your responsibilities as councillor at RBKC?
Yes.
And in the period from 2010 to 2017, what other business or other interests or activities did you pursue in parallel with your activities as a councillor at RBKC?
Socially Conscious Capital was my primary other business.
Right. And what proportion did you generally devote to council business or work as opposed to your own private interests?
Probably about half my time. We did at one stage do a kind of over a month, try to measure how much time one spends in one's council capacity. This was asked of us by the council. And on average, I was spending around 30 hours a week on my council business.
Have you ever had any training or any professional development to assist you in carrying out your role as a director of Socially Conscious Capital?
No.
Have you ever had any training once you became councillor, as councillor, in health and safety matters?
No.
Fire safety?
No.
Social housing management?
No.
The rules or guidance surrounding the subject of consultation with residents?
No.
Equality and diversity?
No formal training, no.
Was there any mandatory training for councillors that existed at RBKC before the fire at Grenfell Tower in June 2017?
When I was elected in 2006, there was no mandatory training as far as I remember. I do think that the induction process for new councillors was improved in ensuing years, and I think councillors who were elected in 2014 were given more thorough induction training than when I was first elected.
And what did that more thorough induction training involve?
I can't give you the details because I wasn't one of the councillors who went through it, I'm afraid.
All right. I'm going to ask you some questions now about your role and particularly oversight that was provided to the TMO. Now, first, I want to ask you some questions about the Housing and Property Scrutiny Committee. Can I begin with IWS 401462, please? this is a report of an investigation, and it's entitled Investigation Report on Long-Standing Complaints of the Kensington and Chelsea TMO by Local Governance Limited, and specifically Maria Momoli, who conducted that investigation. First, is this a document that you've ever seen before?
Not that I remember.
Right. So does that tell us that at no time during your tenure as councillor, and particularly as cabinet member and deputy leader, you never saw this document?
Right now, it does not ring any bells. I don't know what date it was produced.
April 2009. Let's look a little further into it and see if I can ring a bell for you with it. Can we go, please, to page 3, where you can see the executive summary? And it starts, there are a number of tenants, leaseholders and freeholders within the Borough of Kensington and Chelsea who feel aggrieved that their problems have not been resolved by the TMO despite several years of complaining. Now, just pausing there, this is 2009. Did you know that this subject was the subject of a report?
I did not. I was not in the cabinet then, and I was not on the Housing and Property Scrutiny Committee at that time.
No, and in fact, I think you've told us you've never been on the Housing and Property Scrutiny Committee.
No, but I didn't even attend it, obviously, at that time.
No. Well, let's just look a little further down the page then. The third paragraph, the residents' main concerns are around, and you've got the list there, major works, management charges, service charges, etc., communications and performance and monitoring, trust and confidence are some of those listed. And in the next paragraph, but one, further down, the longer one, you can see in the last sentence, the new board needs to win the hearts and minds of those disgruntled residents who have had grievances going back several years. The board must understand its constitutional and legal role and take collective responsibility to spearhead the TMO in its improvement plan. And then at the foot of page 3 and over to page 4, you can see a list of main recommendations, customer care relations, just in heading terms, customer care relations at the foot of page 3, onto page 4, customer services and complaints, repairs, major works and service charges, and then onto page 5, you can see governance issues, corporate policy, financial issues, etc. I don't think I need to read any further into this document. Looking at that, was there ever a time when this was ever mentioned to you or discussed in front of you or even shown to you?
So what I do remember is I think the councillors generally being told that there were issues that the council had with the TMO. I remember being made aware that, I can't remember the name of, anyway, there was a problem with the chief executive. It was problematic. I knew that there were problems in the TMO and that the council did they serve an improvement plan on the TMO? Or anyway, that they were trying to get the TMO's executive function better.
Yes, I see. So you knew about the improvement plan, which was 2010, the year after this report, did you?
I was aware of it. I didn't know the details of it.
Go back a page, please, to the heading Repairs, Major Works and Service Charges we glanced at a moment ago, and see the recommendation under that. You can see the first bullet point is this: the council should take a more robust role to ensure TMO technical services are capable of delivering an effective major works programme and cyclical repairs. Did you know at any time that that had been the subject of an independent recommendation?
No.
Right. Do you know whether the TMO ever acted on recommendations such as this before it embarked on undertaking the Grenfell Tower project?
What I remember being told is that after the improvement plan, there was a new chief executive, Robert Black, brought in, and there were considerable efforts made to strengthen the effectiveness of the board and indeed the executive team. And I do remember during my time as the cabinet member that, for example, the TMO were working on new procurement frameworks and that side of things. But I don't remember this specifically, right, or what happened between this time in 2009. To
be clear, you say the cabinet member. Was that in respect of corporate or in respect of housing and regeneration?
So do you mean when I was cabinet member for civil society? Not. when you say corporate, is that
But I'm
what
just
you mean?
seeking to understand your question. You say, during my time as cabinet member.
I meant cabinet member for housing
Right, and could you just give us the years, please?
from 2013 to 2017.
Very well. So upon becoming cabinet member for housing in 2013, first of all, tell me if this is wrong, but I take it that you didn't see this report.
No.
Did you discuss whether these recommendations had been carried into effect, or the stage at which these recommendations?
I did not know about these recommendations, so I didn't discuss them.
Do you know what the role of the HPSC was in overseeing the implementation of these recommendations?
No, I do not.
And presumably the same would apply to your own role as cabinet member for housing.
Sorry, what's your question?
My question is, I'm assuming you personally, in any role, did not know what the role of any of those committees was in overseeing the implementation of these recommendations.
Not these specific. I did not know about these specific recommendations or this report until just now.
Right. Can we then look at another document, please, which is INQ 30146671. What I'm showing you is the Chartered Institute of Public Finance and Accountancy's 2016 document called Delivering Good Governance. Is this it's quite a striking looking document. Is this a document you've seen before or not?
I don't remember it.
You don't remember it. If we just look at page 90 in it, and look at paragraph 6.9, it sits within the part of this report about scrutiny, and it says principles of good scrutiny, and it says within that the principle the Centre for Public Scrutiny has established 4 core principles of good scrutiny, provides critical friend challenge to executive policymakers and decision takers, enables the voice and concerns of the public, is carried out by independent-minded councillors who lead and own the process, drives improvement in public services. Were you aware of those principles?
Broadly speaking, those are the principles that I thought Scrutiny Committee was meant to do, yes.
How did you come to that understanding?
Do you know, I think it was largely through, when I became a councillor, as I've said, it didn't have very formal training and induction for new councillors. It was more a rather old-fashioned view of learning through experience and almost a process of osmosis, learning from the more experienced councillors.
I see. So you would say that you absorb these principles through experience and hands-on application rather than being taught them?
That's exactly.
From what you could observe, were others around you, other members, for example, of the HPSC, the Housing and Property Scrutiny Committee, aware of these principles?
I would say there was certainly, I wouldn't want to speak for all members, but I would be confident that there were members on the Housing and Property Scrutiny Committee, at least when I attended, who would have been trying to do all of those things.
Right. But can we take it from your evidence so far that this document wasn't shown to or circulated to members of Cabinet or other councillors in 2016 or after?
I don't remember it being sent to me, and if it was sent to me, I don't remember reading it in any detail.
Can we next go, please, to RBK 3063764? This is a document which is appended to the June 2012 RBKC Constitution under Part 5D, and it's called the Local Code of Corporate Governance. Just looking at that page on the screen, is that familiar to you?
It's not something that I have a detailed recollection of.
All right. You don't remember when you might have seen it before?
No.
Right. Is it possible that you never have in fact seen this document?
If it was attached to the Constitution from time to time, as I felt it necessary, I would have looked up parts of the Constitution,
Yes.
but it was not a document which I read from cover to cover at a regular intervals.
No, I understand that. Can I take it then that it wasn't a document that was ever circulated to councillors and with an instruction to familiarise themselves with its text?
Not that I remember, no.
Can we look at page 4, please? Principle 4. And Principle 4 is taking informed and transparent decisions which are subject to effective scrutiny and managing risk. And looking at the first bullet point, it says this: the Royal Borough develops and maintains an effective scrutiny function which encourages constructive challenge and enhances the authority's performance overall and that of any organisation for which it is responsible. Were you familiar with that as a principle?
I would say that is a principle that, yes, councillors who were on scrutiny committees were aware of and familiar with.
And did you understand that principle to have applied to scrutiny of the TMO's activities?
I don't know whether I would have thought of the TMO as an organisation. Depends what one means by for which the council is responsible for. But my experience from attending Housing and Property Scrutiny Committee was that the committee members did indeed ask questions and challenge the performance of the TMO.
If we look at the fourth bullet point down, it says, ensures that effective, I'm sorry, I think it's the fifth, in fact, ensures that effective, transparent and accessible arrangements are in place for dealing with complaints. Were you aware of that principle?
I knew that both the council and the TMO had a well set out complaints process.
And did you understand that applied to the TMO as well as to RBKC?
I was aware that the TMO had a 3-stage complaint process, as I've said in my witness statement.
Yes. And then just below that, it says, ensures that those making decisions, whether for the authority or the partnership, are provided with information that is founded on good quality data and fit for the purpose, relevant, timely, and gives clear explanations of technical issues and their implications. Again, can we take it that you were aware of that as a governing corporate governance principle?
Yes, definitely. The decision makers, i.e. councillors who were on the cabinet, relied on and also challenged the advice that was provided to us by the professional officers.
Right. And 2 bullet points below that, ensures that risk management is embedded into the culture of the authority, with members and managers at all levels recognising that risk management is part of their job. Again, were you familiar with that principle?
I think broadly speaking.
Broadly. Did you understand that specifically to apply to fire safety risks?
Well, in as much as I wouldn't necessarily look at that as being specific to fire safety, but risks relating to fire safety would have fallen under that general umbrella principle.
Yes. Now, can we then go, please, to another part of the Constitution, RBK 3035012. And I'm going to show you Article 6. This is entitled Scrutiny Committees, and it sits within Part 2 of the Constitution. And at 601, it's entitled General Remit, A, General Duties of Scrutiny Committees. And I'll just read these to you. Scrutiny committees are empowered to 1, review and scrutinise decisions made or actions taken in connection with the discharge of any of the Council's functions. 2, recommend and report to the full Council, including committees of the Council or the Executive, including advisory groups, in connection with the discharge of any of the Council's functions. 3, consider any matter affecting the Royal Borough or its inhabitants. 4, exercise the right to call in for reconsideration decisions made but not yet implemented by the Executive. And 5, hold an inquiry into a matter which has been the subject of a report from the monitoring officer or the chief Financial Officer. And if we please turn to page 2, at the very foot of that page, we look at Article 6.03, Housing and Property Scrutiny Committee, membership 11 members, terms of reference, you can see, to scrutinise, and then over the page, 1, at the top of the screen there, the provision, planning, management and performance of all housing services. 2, any partnerships associated with the delivery of housing. 3, social housing regeneration and the housing regeneration programme. 4, supporting people services. 5, the tenant management organisation. 6, housing strategy, housing stock finance and development. 7, corporate asset management. Just looking at that, is it right that the committee's role included review and scrutiny of decisions, first of all, made in connection with the discharge of any of RBKC's functions to do with the provision of housing?
Yes.
Yes. And is it correct that the committee's role included review and scrutiny of consideration of any matter affecting RBKC or its inhabitants?
That's what it says.
And provision of and planning, management and performance of all housing services?
Yes.
Yes. And also the TMO, as you can see. Yes?
Yes.
And would all of that have included the safety, and particularly the fire safety, of residents and buildings managed by the TMO?
Yes.
Yes. Now, is it right that the committee itself had no decision-making powers, but could inquire, discuss and question actions of RBKC Cabinet, RBKC officers and the TMO?
Correct.
And is it right that as a necessary limitation on that function was that the committee could only inquire, discuss and question based on information that it was given?
Yes, or asked for.
Yes.
And then given.
Asked for, either asked for or not asked for, but nonetheless given.
Yes.
It couldn't act without information.
Correct.
It may seem obvious as a question, but do you accept that?
I do.
Yes. Was the Housing and Property Scrutiny Committee empowered to overturn an executive decision that related to housing?
No, as it just said, it could call in a decision which had not yet been implemented and ask for the Cabinet or decision maker to reconsider that decision.
Did the HPSC ever refer or exercise its powers to refer back to Cabinet any decision concerning particularly the Grenfell Tower project?
Not that I remember while I was Cabinet member for housing.
And as far as you're aware, did the HPSC ever raise any issues with Cabinet relating to the Grenfell Tower project?
Well, not in terms of the decisions that Cabinet made about Grenfell Tower, but
Right.
those decisions, as I say in my witness statement, were really limited to agreeing the budget originally and then the 2 increases in budget.
Yes, so I think the answer to my question is no. HPSC never raised any issues with Cabinet.
Not with Cabinet that I recall, no.
And as far as you're aware, did the HPSC ever raise any issue concerning fire safety specifically with you as the Cabinet member for Housing, Property and Regeneration, whether in relation to Grenfell Tower or any property in TMO stock?
They did frequently, during my time as Cabinet member, ask questions about fire safety. Especially, there was an issue which repeatedly went to the Scrutiny Committee about having the fire doors across the HRA stock. And there was an issue around, I think it was confirmed quite early on in my time as Cabinet member that all the tenanted properties that had their doors replaced, that they were compliant, but there was an ongoing issue about some leaseholder doors.
Yes, so that controversy, if I can put it like that, that was raised by HPSC with you as Cabinet member.
While I was the Cabinet member, I wouldn't necessarily say it was raised with me, but it was raised by the Scrutiny Committee while I was the Cabinet member.
Yes. Can we then look, please, at the statement of Councillor Sam McAver? This is RBK 3029923, and I'd like to go, first of all, to page 1 to show you what this document is. It's his witness statement to the inquiry, and at page 9, if we can turn to that, he says this at paragraph 40. Page 9, I think that's it, under the heading Fire Safety. paragraph 40, RBKC borough-wide scrutiny of fire safety falls under the Community Safety and Emergency Planning. The Constitution, Article 6, paragraph 6, or Article 605, provides that this was within the remit of the Cabinet and Corporate Services Scrutiny Committee. I understand that the Borough Fire Commander participated at the meetings of that scrutiny committee. Do you agree with him that borough-wide scrutiny of fire safety was within the remit of the Cabinet and Corporate Services Scrutiny Committee?
I think that is probably correct.
Was that always the case, so far as you can recollect, during your time as councillor?
So what I do remember, when I was the cabinet member for civil society, community safety fell under the remit of that cabinet position, and that community safety did include liaising with the London Fire Brigade and LFIPA, and I would have attended the Cabinet and Corporate Services Scrutiny Committee at that time. So I do remember, for example, in those 2 years, there were issues around potential closures of fire stations in the borough, which I wrote to LFIPA about and tried lobbying against. So in that regard, it would have fallen under the Cabinet and Corporate Services Scrutiny Committee. But I don't think that means that Housing and Property Scrutiny Committee were not, it wasn't within their remit to be able to ask questions about fire safety within the HRA stock.
Right. And you said when you were in the, you were acting as cabinet member for civil society. What were those years?
2011 to 2013.
That's 11 to 13. And just to be clear, so that we're clear, you were a member of the Cabinet and Corporate Services Committee. That was 2010 and 2011.
Yes.
So
I was not. So that I was.
They didn't overlap.
They didn't overlap.
Right.
You couldn't be a member of the cabinet and sit on a scrutiny committee.
No, well, quite. Okay, so I understand it. So you were on two. I follow. You were not, I think, a member of the Cabinet and Corporate Services Scrutiny Committee.
Not while I was on the cabinet.
No.
So I was up until April 2011, and then I was appointed a member of the cabinet as cabinet member for civil society, and I stopped being a member of the Cabinet and Corporate Services Scrutiny Committee at that time.
Committee, correct. I understand that. Were there any councillors who sat on both scrutiny committees simultaneously, Cabinet and Corporate Services Scrutiny Committee and the HPSC?
There could have been. I can't remember if there were.
Looking then, please, at that part of the Constitution to which Councillor McIver refers, this is RBK 3035012 at page 4, paragraph or Article 605. If you look...
So can I just look above to see
yes, look above. Look at page 3 then, where it starts.
Okay.
And under terms of reference, business handled by the full cabinet, which does not fall within the remit of another scrutiny committee. And then if we turn to where I want to go, page 4, under sub-article 4, if you look at Roman 14, you can see drugs, community safety, and emergency planning. So did fire safety fall within the ambit of that committee? It looks like it did.
Yes, I agree. It looks like it did.
Yes. So do you recall the HPSC ever raising an issue with you concerning fire safety in RBKC stock? Apart, I suppose, from the leaseholder fire doors question.
Well, I remember fire safety across the HRA was something that was reported to the HPSC at least once, if not twice a year, in the annual and mid-year reviews that the housing department presented to scrutiny committee.
Right.
And there were standing items within those reports on fire safety across the HRA stock as managed by the TMO.
And what about within the Cabinet and Corporate Services Scrutiny Committee? Was there a similar reporting system?
Not with regards, I don't believe, the council-owned stock in the HRA.
I see. Can we go to your first witness statement, please, at page 7 and look at paragraph 30 together? You say there, that, in the third line, in relation to the TMO's performance against its duties and responsibilities as the council's managing agent, we rely primarily on housing officers as professionals in their field who monitored the TMO against the requirements of the MMA to check and keep the Cabinet and Scrutiny Committee informed of any potential problems or shortcomings. In return, councillors were able to question officers about their findings. We did not rely exclusively on reports directly from the TMO because any such direct information was supplemented with the assessment and advice of the council's housing department. Do you know which officers drafted reports for committee meetings?
Well, they would normally go out in the name of Laura Johnson as the Director of Housing, so I assumed that I don't know whether she actually drafted them all, but she was, I'm sure, confident that they were correct and was willing to put her name to them.
How often were reports of housing officers, such as those which bore Ms Johnson's name at the bottom, questioned by members of the committee? The HPSC, I mean.
I think they would be regularly questioned.
Were the annual and mid-year TMO performance reports, which were sent up to committee, ever questioned by the HPSC?
I'm pretty sure they were. I don't remember exactly now, but they would have been, yes.
Can you think of a specific example when that took place during your time observing as council member for Housing, Property and Regeneration?
It's very hard for me now to try and remember specific discussions around specific agenda items from meetings which happened however many years ago it is now. I'm afraid I can't give a specific example of that specific question on that specific agenda item from one of those specific meetings.
No. I mean, do you remember any occasion on which you would ever call for an examination of or a spot check of any underlying data on which those reports were based?
Personally, I took the view that I was relying on the report produced by the Director of Housing because I was confident that she and her department were checking the information that was being provided to them by the TMO.
So what were you scrutinising? Or what was being scrutinised?
Sorry,
Well, the role of the Scrutiny Committee is to scrutinise. If you're not asking just to spot check the underlying data to make sure that it adds up to the conclusions which are being reported to you, what were you actually scrutinising?
Remember, I was not on the Scrutiny Committee.
No, that's why I rephrased my question. What was the Scrutiny Committee scrutinising?
The Scrutiny, they did ask questions. I can't remember of that specific item on the agenda, but they frequently ask questions of the TMO and the Housing Department, for example, wanting updates on the fire doors, wanting to know what's happening, what happens if a leaseholder refuses to upgrade it, who's responsible for enforcing that. I remember there was some sort of disagreement, whether it was the London Fire Brigade or the council who had to do it, trying to get to the bottom of those sorts of questions.
Yes, I see. Can we look at RBK 3033744? This is... let's have a look at page 1 of this to start with. This is the first page of Councillor Marshall's witness statement to the inquiry. And I'll just show you page 2 at the bottom, at paragraph 11. He says this: if the committee disagreed with a cabinet member or officers, it could not take further action other than to continue to raise the matter in public at its meetings. The scrutiny process could be frustrating because we were often given information or told about something after the event. We were reliant on officers giving us comprehensive information on the activities in their departments and had almost no independent support. Our ability to scrutinise was also constrained by the large number of matters within our purview, which had to be covered in 6 meetings a year, typically of 2 hours' length each. This high-level approach is apparent in the minutes. First of all, do you agree with what Councillor Marshall says there?
He's better placed to make those judgments, having been chairman of the Scrutiny Committee, than I am, and I wouldn't want to challenge particularly that view.
So you would, right. That's very fair. Can we see how Councillor Mackover puts it? Can we go back to his witness statement, please, page 2, and go to paragraph 9? He says there...
Sorry, my thing hasn't caught up.
Page 2, paragraph 9.
I'm still on Councillor Marshall's.
Yes. RBK 30299923. Page 2, paragraph 9. It says the HSPC, I think that should be the HPSC, met between 4 and 6 times a year and had no research or support staff. Papers were generally provided by the executive and the housing and property teams. The governance team distributed the agenda and took the minutes. At around 2.5 hours per meeting, there was a strict practical limit to what the HPSC could do. Members did not receive any documents other than those provided in the pack of papers for each meeting. Members would receive these a week in advance to read and form the source of scrutiny questions. Do you agree with what he says there? This is Councillor Mackover.
Yes, I would just. I wasn't a chairman of a scrutiny committee, but I thought that the chairman of scrutiny committees, there was a scrutiny steering group, which consisted of the chairman of the different scrutiny committees, and there was some resource available there, and it was possible for them to ask for more officer resource if they needed it. But generally, I think those are fair points.
Right. Were these limitations, to your knowledge, ever the subject of discussion or complaint among the members of the HPSC?
Councillor Marshall, as the chairman of the HPSC, I remember thinking he was a very good and effective chairman of a scrutiny committee because he cared and took a lot of time to read papers, question them. He made a point in my capacity as cabinet member of the corporate property team, which had an awful lot of decisions going to the scrutiny committee. And when they were put on the forward plan, he asked the relevant officers in that department to kind of send more detailed explanations of what these key decisions were so that he could better review them before they go on the forward plan. So I think he was effective and proactive. But if he feels he still didn't have sufficient resources or time to do as much as he'd have liked to have done, then again, I wouldn't challenge that.
Yes. I mean, for example, let's just focus on one part of what he says. This is Councillor Mackover. He says that the HPSC had no research or support staff. First of all, is he right about that?
If he says that, I'm sure he is.
Right. And was that ever the subject of discussion or complaint from what you could observe among the members of the HPSC?
I don't remember that being the case. And I think that if the scrutiny steering group, the group of councillors chairing scrutiny committees, had requested some specific resource, I think that either was available or would have been made available.
Can you tell us which scrutiny committee was responsible, just going back on a point from before, was responsible for scrutinising health and safety matters?
I wouldn't want to claim any expertise on answering that question, but from what you have shown me, health and safety more generally across the council's functions, I would have thought would be scrutinised by the Cabinet and Corporate Services Scrutiny Committee.
Yes.
But health and safety, as it specifically concerned council-owned properties, could have been scrutinised by the Housing and Property Scrutiny Committee.
So it could have been.
I personally would have thought it would fall more within the remit of HPSC than Cabinet and Corporate Services.
Right. was there a clear, to your recollection, was there a clear allocation of scrutiny responsibility for TMO stock, so far as health and safety was concerned, as between the HPSC and the Cabinet and Corporate Services Scrutiny Committee?
I think that on the whole, there were quite clear distinctions between the remits of the different scrutiny committees. I think the one which did sometimes cause, whether confusion is the right word or a lack of clarity, was the Cabinet and Corporate Services Scrutiny Committee, because it had potentially such, it was scrutinising the Cabinet, so it could claim to be scrutinising any decision that goes to Cabinet, and the corporate services is such a broad remit. So I think there could be a lack of clarity there. But again, my view was that the Housing and Property Scrutiny Committee was responsible for not just the council homes under the HRA, but also the council property assets more broadly.
Yes, thank you. Mr. Chairman, is that a convenient moment?
If that suits you, I think it is. Yes, thank you. Well, Mr. Feilding-Mellen, we're going to have a break now so we can all get some lunch. We'll resume, please, at 2:00. And I have to ask you, as I have asked all witnesses, please don't talk to anyone else about your evidence or anything relating to it over the break.
Okay.
Right. Thank you very much. Would you go to the usher then, please? Thank you. 2:00 then, please.